I was thinking about this morning, and I thought I should just tell you that, I'm by no means the leading authority on these issues. I can only convey to you my experience and my interpretation of the rules and the case law and the procedure. But possibly very soon, I'm going to have to be arguing before one or more of you, and you're going to be the ones making the decision. So my purpose here, and please understand that, is to guide you through the process so that you can educate yourself, and that's what's going to be expected of you. Because essentially, I'm going to be wanting to argue one case or one side, and I'm going to have an opponent who wants to argue the other side, and at the end of the day, it's up to you to make the decision. So read for yourself. Don't necessarily believe everything everyone tells you, including me. I believe it or not, and I won't tell this to my husband, but I also make mistakes. So never admit it to him. So please know that through this training, this is not supposed to be the be-all and end-all. This is supposed to be an induction, an introduction to civil procedure in the High Court, and it's supposed to give you a platform from which to lift yourself to the level that you need to be in order to practice as a High Court judge. So please bear in mind that what I'm telling you here is not cast in stone, in the sense that you have to make up your mind on many of these issues yourself. And many of these issues are difficult and complex legal issues, even when it comes to procedure. And you will have to develop the ability to know what to do in circumstances where it becomes complex. So I'm trying to, on a very basic level, just introduce you and really navigate you through the process so that you at least have an understanding of what's happening. All right. So that takes care of suspectus de fuga. We have another matter that we were promised. Did you bring? Yes. Okay, so let's have a look at that. Just remind me, what was that about again? That was the adultery.
And claim against third parties.
Alwyn van Straten. Surely he didn't sue for adultery. Okay, but the van Straten matter, it was an urgent interdict. Okay, so this one, I suppose, hasn't got anything to do with what we discussed, because that was an urgent interdict. Mr. van Straten is a well-known liquidator, and that was an urgent interdict for eviction. Okay, so this is Sibonga. It's a 2014 matter, so it precedes the judgment by Judge Witele, if I'm not mistaken. Okay, so it says in paragraph 13, the issues to be determined by this court are thus whether the first defendant could give evidence against the plaintiff in respect of the claim against the second defendant, and secondly, whether the claim itself is sustainable in law. And then the further question as to punitive cost order, which we won't. Then the ruling on marital privilege. So you know what marital privilege is. I don't need to explain that to you. So a spouse cannot be forced to testify against. I can't be forced to testify against my husband. We, while we're married, and even after, we have, during our marriage, we are protected in terms of the Civil Proceedings Act by privilege between spouses. Okay, then whether the delict of adultery is still sustainable in law. The question posed by this court concerns the continued existence of the delictual action of adultery. A similar question was coincidentally also Miramoto posed by the Supreme Court of Appeal in RH versus DH. The reference is there in paragraph 24. And then they referred to the context within which the question was asked in the Supreme Court of Appeal in South Africa, which is the context in which the question arises is the recognition by our courts that while the major engine for law reform lies with the legislator, the courts are nonetheless obliged on occasion to develop the common law in an incremental way. These occasions are dictated firstly by section 39(2) of the Constitution. That's of course the South African Constitution, which imposes the duty on courts to develop the common law so as to promote the spirit, purport and objectives of the Bill of Rights. So that would be the same objective in Namibia. So courts would have a duty to develop common law in keeping with so for instance, insofar as suspectus de fuga is still a relevant remedy in Namibia, courts are expected to develop that and develop case law that's in keeping with the Constitution and consider whether such relief is in fact still relevant. Then they deal with the boni mores of society, etc., etc. In the more recent past, our courts have come to recognize, however, that in the context of the law of delict, the criterion of wrongfulness ultimately depends on a judicial determination of whether, assuming all the other elements of delictual liability to be present, it would be reasonable to impose liability on a defendant for the damages flowing from specific conduct, and that the judicial determination of that reasonableness would in turn depend on considerations of public and legal policy in accordance with constitutional norms. So they say this court has affirmed this approach in the context of the determining wrongfulness in delictual claims, and of course the kind that one has in adultery and claiming against a third party is one in delict. Then they deal with the role of the common law. Okay, so it seems to me that this issue wasn't dealt with in the High Court in this matter, because they say in paragraph 32, although this court is at a disadvantage considering an issue when not dealt with by the High Court, it can and does happen that issues are identified on appeal for the first time by this court, which needs to be addressed in argument, giving the parties adequate notice to prepare both written and oral argument on an issue. As occurs with other courts of appeal, public policy also informs the element of wrongfulness in delictual liability. This was acknowledged by this court in the context of the Aquilian action. The inquiry is thus whether the act of adultery is wrongful for the purposes of the delictual claim in question, as was also posited by both the Supreme Court of Appeal and the Constitutional Court in DE versus RH. That's the matter, the South African matter they continuously refer to. If not, there would be no delictual claim without wrongfulness. So it's whether the adultery was wrongful. As I've said, the element of wrongfulness is determined with reference to the legal convictions of the community and public policy, which is now informed by our constitutional values and the changing nature of the prevailing norms of society. This inquiry is ultimately whether public policy means that a claim founded on adultery should still form part of our common law. This court is in a position to make determinations on public policy. The common law context and nature of the inquiry, being a dispute between the plaintiff and the second defendant, does not require an input from the Attorney General. It would in any event not be apposite. Even where a common law rule has been challenged on the grounds of being in conflict with the Constitution, that has not been found to be necessary or apposite. That's just when you have to join the Attorney General. You know that when you're taking on a statute for being unconstitutional, you need to join the Attorney General. What they're saying here is when you changing the common law, it's not necessary to join the Attorney General. Okay, let's see what they say. They deal with what is in the Supreme Court of Appeal action DE versus RH. Okay, then they deal with the High Court in Van Wyk versus Van Wyk. Noted a softening of societal attitudes to adultery in this country. Then they deal in paragraph 42 of that judgment with Van Wyk versus Van Wyk. Which is important to keep in mind in 49 of the judgment, as in RH versus DE, the plaintiff in this matter would appear to have been motivated by vindictiveness and anger, looking to the second defendant as a scapegoat for that anger. The actual award for damages would hardly justify a lengthy High Court trial. In this case, the plaintiff had, both in his pleadings and in evidence, admitted his own adultery, even after or even at the time of the breakdown of the marriage. But ultimately, in its respect of the determination of, it is in respect of the determination of wrongfulness, with reference to the legal convictions of the community informed by our constitutional values and norms, that it is no longer reasonable to impose delictual liability for a claim founded on adultery. Whilst the changing societal norms are represented by a softening in attitude towards adultery, the action is incompatible with the constitutional values of equality of men and women in marriage and rights to freedom and security of the person, privacy and freedom of association. Its patriarchal origin, perpetuated in the form of the damages to be awarded, are furthermore not compatible with our constitutional values of equality in marriage and human dignity. And then they again deal with DE. It seems to be me this DE versus RH matter we should go and read, because it appears to me that it's very relevant. So the conclusion I reach is that the act of adultery by a third party lacks wrongfulness for the purposes of delictual claim of contumelia and loss of consortium. Public policy dictates it is no longer reasonable to attach delictual liability to it. The action is thus no longer sustainable. This is a judgment written by Smuts, and did Shivute and Mainga concur? Concurring, yes. So there you have it. Thank you. So if you want to go into the practice of divorce law, then don't sue the third party. Okay. That doesn't change anything that we did yesterday regarding divorce law before you as on an action. I mean, we didn't deal with third party claims. So please be mindful of that and of the situation that has changed in Namibia. All right. Good. Anything else that we discussed yesterday that we wanted to speak about today? I think we've got everything. Good. Thank you. All right. Absolution from the instance. So I'm jumping. Sorry, we are here. So I'm going to deal with absolution from the instance. It's one of the only issues I'm going to be dealing with here. I just want to deal with that now under pleadings, so that we can finalize that part. It's actually something that probably falls better under trials, but we don't have a specific section for trials in this session. All right. So absolution from the instance. It's strictly speaking, it's three instances. It's either at the trial if the plaintiff doesn't show up. It's at the end of the close of the plaintiff's case before the defendant has opened its case, or at the end of the trial. So you have three instances where you can actually apply. It's more often than not actually only applied for at the close of the plaintiff's case before the defendant opens its case. So it's either at the start of the trial where the plaintiff doesn't show up. You can seek absolution. So they haven't made out a case. Or it's at the close of the plaintiff's case, mid-trial, before the defendant has opened its case. It depends whether you're seeking absolution or whether you're seeking a dismissal, because so it doesn't matter. On absolution, the test is the same. Absolution is absolution, irrespective of when you seek it. Once you've closed your case, I can hardly think that you would want to seek absolution. You'd probably want to seek a dismissal, but it might be for certain reasons that you seek an absolution. So essentially, absolution in this jurisdiction is normally sought at the close of the plaintiff's case, or at the start of the trial. I mean, absolution and or default judgment, depending on tactically and strategically where you are at that point in time. If you seek absolution, it doesn't matter when in the proceedings you seek absolution, the test will remain the same. It depends whether you're seeking absolution or whether you're seeking a dismissal, sort of a final, this is now the end of the matter, because the test differs significantly between seeking absolution and seeking a dismissal. Okay. It's obviously more difficult to get absolution than it is to get a dismissal, for the simple reason that the test is a low threshold test, in the sense that for the plaintiff, in favor of the plaintiff. But I'll deal with the test now and the principles relating to absolution. It's exactly because the court hasn't heard evidence. So the plaintiff is there, its case is set down for trial. It's exactly the same thing. So what you would say to the court in absolution is there's no evidence or sufficient evidence when you deal with the test, you'll understand, on which a reasonable court might find in favor of the plaintiff. So there's no evidence, so I'm seeking absolution from the instance. That's why you can do it if there's no, if the plaintiff gets up and says, it may as well happen, the plaintiff may say, I close my case because on the pleadings this is in dispute, or that's this is in dispute and this is not in dispute. And given what's in dispute on the papers, I close my case without leading any evidence. It's happened. It may be then that you may seek absolution. Similar situation. So if the plaintiff doesn't show up, you can seek default judgment, or you can seek absolution. You're entitled to seek absolution because no evidence has been presented on which a reasonable court could find in favor of, might find in favor of the plaintiff. So before we deal with the principles of absolution and the test, the effect of an order granting absolution doesn't mean it's the end of the line for the plaintiff. So it means that a plaintiff against whom absolution has been granted can come to court again. So the doors of the court are not closed. It's not a res judicata issue. The plaintiff, if it can bring other evidence, can come to court again. Okay. Which is why, as in my practice, I tend to not want to seek absolution. If I think that if I'm confident, and it's happened once or twice, if I'm confident that I will get absolution from the instance, I simply get up, close the defendant's case and seek a dismissal without leading any evidence because I want it dismissed. Okay, because there's a big difference. If it's dismissed, it's over and done with. I've closed my case, everyone has had their say, even though I haven't presented an evidence at all. But there are instances where you want to get absolution because you're not sure that you'll actually get a dismissal. Okay, so that really depends on the practitioners. It's unfortunately something that's becoming par for the course in the sense that if you're in a trial and the plaintiff closes its case, more often than not the opponent gets up and says, I want to apply for absolution. It's something that unnecessarily leads to delays. It's something for which extempore judgments should be given, in my view. It's something which defendants abuse in order to get a postponement of a matter in a sort of an indirect fashion and prolong the inevitable. So when it is properly used, it's a very effective tool. When it's abused, it really only leads to delays. And irrespective of a cost order, it's interlocutory, although there's authority to say it's not interlocutory and therefore Rule 3211 doesn't apply, but I mean that's probably still debatable. So essentially, it's important for a judge to know when it's abused and when it's not being abused. Right. Test for absolution. Our Supreme Court, in the matter by Acting Judge of Appeal Mtabanengwe in Stier and another versus Henke. The reference is Volume 1, Namibian Law Reports. Where's the year? I must have. I'll check the 2012. Thank you. Volume 1, Namibian Law Reports 370, page 370. At page 373C to I, he set out the test for absolution, which is accepted, and this is really a tried principle. With reference to the Claude Neon Lights matter, I think it's not in this. Okay, anyway, Claude Neon Lights, it's referred to in the Stier and another versus Henke matter, so you can have a look at that, because Claude Neon Lights, South African matter, Appellate Division of 1976, and in that matter really is the tried principles were set out and it was accepted and applied in our jurisdiction, and they are the following. When absolution from the instance is sought at the close of the plaintiff's case, the test to be applied is not whether the evidence led by the plaintiff establishes what would finally be required to be established, but whether there is evidence, and this is why answering your question about why if no evidence was led can you seek absolution, but whether there is evidence upon which a court, applying its mind reasonably to such evidence, could or might, not should or ought to, find for the plaintiff. This implies that a plaintiff has to make out a prima facie case in the sense that there is evidence relating to all the elements of the claim to survive absolution, because without such evidence, no court could find for the plaintiff. As far as inferences from the evidence are concerned, the inference relied upon by the plaintiff must be a reasonable one, not the only reasonable one. The test has from time to time been formulated in different terms, especially it has been said that the court must consider whether there is evidence upon which a reasonable man might find for the plaintiff, a test which has its origin in jury trials when the reasonable man was a reasonable member of the jury. Such a formulation tends to cloud the issue. The courts ought not to be concerned with what someone else might think. It should rather be concerned with its own judgment and not that of another reasonable person or court. Having said this, absolution at the end of the plaintiff's case, in the ordinary course of events, will nevertheless be granted sparingly, but when the occasion arises, a court should order it in the interest of justice. Okay. A plaintiff is required to present evidence to support every element of his claim as set out in the pleadings. I can refer you to Supreme Court of Appeal matter in South Africa. That's Gordon, Lloyd, Page and Associates versus Riviera. The citation is 2000. I'll provide a complete list of all the case law tomorrow or Thursday to Lorraine to circulate to you, but you can write this down. 2001, Volume 1, South African Law Reports, page 88, Supreme Court of Appeal at page 92. So there it's set out that a plaintiff is required to present evidence to support every element of his claim as set out in the pleadings. So therefore, to answer your question earlier, when a plaintiff doesn't pitch up, his pleadings are before court, the matter is set down for trial, the defendant is entitled to accept that there's no evidence before the court and therefore there's no evidence to support the particulars of claim and therefore absolution is competent. I would not move for absolution then, but you can. So your question is probably more directed at whether it's from a litigant's point of view, whether it makes sense to apply for absolution then. Probably not, and whether I would depends on the circumstances, but you are entitled to do that, and you're entitled to do that because there's no evidence before the court based on which the court then may find in favor of the plaintiff, might find or could find in favor of the plaintiff in respect of all the elements. All right, so at the close of the plaintiff's case, it must be inferred that the court has heard all the evidence for the plaintiff and that any further evidence that would be forthcoming if the case was to continue would only be to the detriment of the plaintiff's case. That's Erasmus Superior Court Practice at B1-293. So essentially when the plaintiff has closed its case, the court must assume that's the high watermark for the plaintiff. Nothing else is going to support the plaintiff's case. This is for purposes of absolution. Okay. So when an absolution order is granted, it means that the plaintiff can come again. The doors of the court have not been closed to him. It may be that that you won't be able to apply if you need to close your case, you may be in a different position. I can't fathom all the circumstances. It really, from your perspective, doesn't matter. It's from a litigant's point of view. So it really is for the litigant to decide whether he or she wants to apply for absolution in the circumstances. So they would strategically, from a litigation point of view, say it's better to apply for absolution or to apply for... I wouldn't apply as a practitioner for absolution where I'm sure that I'll get actually a dismissal. I wouldn't, because of that reason. But the thing is, there are instances where, and of course, if you only apply for absolution at the end of the defendant's case, may still grant absolution, which means that you will be mulcted in costs. Yeah. And remember, if you are not certain that, and this is just one of the considerations I've had in my practice, so I can only share with you my personal experience regarding absolutions and dismissals. If, for instance, you are not certain that you will get a dismissal, and if you're not certain about that, and you also don't want to call witnesses for the defendant because you fear that that might actually support the plaintiff's case, then you're in a bit of a pickle, because if you close your case nevertheless, the issues are done and dusted. You can never revisit them. You've had your chance. You've taken the decision not to lead any evidence, and you just have yourself to blame. In that instance, you may want to rather apply for absolution and hope that the plaintiff says, well, I don't have better evidence, I'm not coming back. So that is an instance where, for instance, I have in the past applied for absolution instead of proceeding, because I'm not sure the witnesses, especially external witnesses, they say they will support the defendant's case, but I fear they may also make concessions under cross-examination, which will support the plaintiff's case, so I don't want to necessarily bring that evidence before court. That's a decision a litigant needs to make. So, because the plaintiff has the responsibility to call witnesses to support his case, and of course the defendant has no responsibility to support the plaintiff's case by way of evidence. So it's really a strategic issue, but there are instances where you will have to apply for absolution instead of proceeding with your case. The court, on a balance of probabilities, decides. So it's a higher threshold test for the plaintiff. So what you would have, if I can refer you again to the authorities, Steer and another versus Henke, it's whether the court should or ought to find, not could or might. So it's a more difficult test for the plaintiff. It's easier to survive absolution. It's more difficult to survive at the end of both parties' cases. So if the lack in the evidence is so glaring that there's no way, or a specific necessary allegation has not been supported by any evidence, then court wouldn't find at the end of the defendant's case, even if no further evidence is laid. And then, of course, so it's a more stringent test for the plaintiff and a more relaxed test for the defendant, if I can call it that, whereas at absolution, the court would be more lenient. So it's could and might, not ought or should. I've had an instance where the court has said that it should have been absolution. I didn't seek absolution. You need to make application. I didn't seek absolution. The court found that we should have instead applied for absolution, and therefore, the end of the case, it was dismissed, but we were only, so it has a cost implication. The court won't grant absolution if I proceeded and stated the case and the court has heard the merits. The court might then say, well, you should have actually applied for absolution, and as a result of that, I'm not giving you costs past absolution stage. And in fact, as a plaintiff, if a defendant applies for absolution and I oppose that, of course, as representing the plaintiff, I would insist on a cost order, that the application be dismissed with costs. And if absolution cost orders are given, I mean, it's a balance. You don't want to deter parties from seeking absolution in instances where absolution is apposite, where they should be seeking absolution. But you also don't want parties to abuse this just to delay justice, just to delay the issues. And in the second instance, one would expect that the courts would be more strict with cost orders, to say, well, I'm going to give a special cost order because this was a clear abuse, and that would be within the discretion of the court. So, well, I mean, granted that it's sought, but anyway. So, I'm just saying that it's a difficult balancing act. Using costs to deter parties from abusing the process, but not using costs as a means to disencourage litigants from ever seeking absolution, because there are a number of instances where absolution is a very handy tool. Does that make sense?
Yes.
Then close of pleadings, which is the last one of the topic of yesterday, which I want to deal with, and then we can take a comfort break. So close of pleadings is called litis contestatio. That's just, again, a very fancy Latin term to refer to the close of pleadings. You'll find reference to that in Rule 51 of the rules. It is any party joins issue without alleging any new matter and without filing further pleadings. So, for instance, if there has been a, let's say, so there's been a summons, there's been a plea, and then This was 15 days, the court said in the case plan. And then there was another 15 days for a replication to the plea. This was filed, this was filed, this wasn't filed. 15 days expired. Nothing happens. You're not obliged. You must file a plea. You're not obliged to file a replication. In many instances, you don't have to file a replication. So this wasn't done. Nothing happens to the plaintiff because they haven't filed a replication. They don't need to file a replication. It's only that they're given the opportunity in the case plan. Then it means that when the 15 days expired, close of pleadings automatically happens. Because what has happened is once the plea was filed and nothing was done further, it means that the plaintiff has joined issue with the plea. In other words, it says, these are then the issues. I agree that these are the issues between the parties. I have nothing more to say. Therefore, close of pleadings have happened. You follow? Does that make sense? Okay, that's one instance. If that's the last day for filing a replication or subsequent pleading has expired and no such pleading was filed, that's really, I suppose, this is actually more example 2. Example 1 is either you haven't filed a plea or you haven't filed a subsequent pleading after replication, because as you will remember, you still have rejoinder and rejoinder. So you haven't filed anything after the replication. So this would be something that the defendant files, and this would be something that the plaintiff files. This would be filed by the plaintiff. So it's plaintiff, defendant, plaintiff, defendant. Same with counterclaims. So the question is, I suppose, a more complex question, and I'm not sure that I know the answer necessarily. What about an instance where you have a main claim and a counterclaim? So do the pleadings close at the same time? Do they close at different times? So what you're saying is the main claims papers, let's say that we are here with the main claim. Replication was filed, and there was nothing after replication. But now there's this counterclaim, which only obviously starts here, because it can't start there, it starts here. Then there's a plea, then there's a replication, and now there's time for a rejoinder. So this is done, and this is done, but this isn't done. Are you saying to me, your suggestion is that for the main claim, pleadings have not closed, it will only close here. Close of pleadings is then delayed until the counterclaim is finalized. Is that what you think? Who agrees with that view? And the others then all say they close at different times, or you don't have an opinion. Who says they close at different times? Okay, so she's now amplified or supported why she says at the same time. Who agrees? Okay, who doesn't agree? Who doesn't have an opinion? The case plan will certainly cater for when pleadings are filed, but it wouldn't cater for close of pleadings. It'll only set out the timelines. So it won't have a date saying, and then on 15 November 2017, pleadings will close. Yes, definitely. And they said, this will be filed then, that then. But the question is, do the pleadings for the one close at the same time as the pleadings for the other? I think perhaps the question becomes more pertinent, not so much from a procedural point of view as you've indicated, which makes sense because you have a plea and you have a counterclaim. These two are connected, and of course you can't have a situation where the one then proceeds to trial and case management while the other one's pleadings are still closed. But it really is that the one is just lagging a bit, waiting for the other one to get. So in my view, considering the rules and considering the authorities, I would say the main claim has closed and the counterclaim is not closed, so this one will wait for this one to close. Because consider for a moment I withdraw my main claim. What happens to the counterclaim? It remains a claim, substantive claim in its own right. It doesn't go away. So therefore you have two substantive separate claims. It's just that for convenience and from a logistical point of view, the rules allow a party to actually bring them together. But I'm not necessarily, this is my view on the subject, and that's not something that I know of that's been decided in our jurisdiction. But essentially, the importance comes in, I suppose, where it's important for a party to have reached close of pleadings. Say, for instance, one of the parties dies. Where are you? Now there's a liquidator. Are you before litis contestatia or after litis contestatia? So it becomes a relevant consideration less often, because more often than not things run their course and all the pleadings are closed, and it doesn't matter which one closed when. But consider for a moment an instance, and there are such instances in law, where litis, and you can read up about the importance of litis contestatia to know whether litis contestatia has actually taken place. And in such an instance, it would be one of those where it would be difficult to decide if your thinking is that the main claim, the close of pleadings in the main claim, is subject to close of pleadings in the counterclaim, which inevitably usually would be longer, further along than the main claim. So, so that's why these things are important considerations. All right, the parties agree thereto in writing and files same with the registrar. So the parties can write each other a letter and say, look, I think pleadings have now closed. And the other party says, yes, I agree. And then they write to the registrar a signed letter or a report or whatever to say, look, pleadings in this matter has closed. And then, of course, the court declares the pleadings closed. So believe it or not, parties can sometimes disagree, and it can sometimes be unclear whether pleadings have closed. But it's important to know whether pleadings have closed for a number of reasons, some of them being part of substantive law, but the most important and pertinent one for purposes of this course is that the matter continues here. So we can accept that we are done now with the pleading stage of this course, and therefore I can now safely say that you are now here. We are proceeding to pretrial procedures, case management, and interlocutory motions, which we will be spending the rest of this course on. Rule 51 says that it must be on application of a party. So court doesn't go around making orders just left, right, and center as it pleases. If there's a need for a party to have the pleadings declared closed, for whatever reasons, I don't think it is a procedural step that's often used, but there are certainly instances in which it is applicable, which is why the rule is there. The court doesn't go around making declaratory orders or whatever just because it can. The court will assume that a party has joined issue without alleging any new matter, or the last day, especially number 2. The last day for filing a replication or subsequent pleadings has expired and no such pleading was filed. Now, an instance can arise where that has happened, one or two, option 1 or 2, where that's happened. But one of the parties have written to the other party saying, look, I need to replicate, but I need to consult my witnesses who are presently somewhere else in the world, and I'm only going to be able to consult next month or 2 months' time, and therefore I need time to file my replication. And then the other party says, no, pleadings have closed, and I'm going to make application to court to declare these pleadings closed. You may want to seek an extension of time as the defendant or the plaintiff to file a replication. The defendant says, no, I'm not giving you that. I'm going to apply to court to declare that the pleadings have closed. And then the court will need to weigh up whether it's going to grant the extension or declare the pleadings closed. So we're going to be dealing with discovery, expert evidence, request for trial particulars, witness statements, indexing and pagination, practice directions, managing a court diary and delivery of judgments, cost awards, and I'm hoping to finish all of that before lunch, and then we'll deal with judicial case management in the afternoon, and then I'm going to be spending the greater part of tomorrow with interlocutory matters. So this afternoon we'll have a look at judicial case management as a whole, notice the importance of a notice to defend, overriding objectives of judicial case management and civil procedure, obligations of the parties, docket allocation, case planning, the case management conference, the pre-trial conference, and the status hearing. Hopefully we'll be able to finish all of that today. So we have a long day ahead of us. Please, if you feel that I'm going too quickly, or you want me to just take a step back and just explain something again, please, you're more than welcome to ask me. I would be more than happy to go back. It's important that we lay a foundation here from which you can then springboard to where you need to be. Okay, discovery, rule 28. Now in the files that you got, you'll find that under witness statements and discovery. It's indexed page 61 would be the first filing notice, plaintiff's discovery affidavit and discovered documents. And then you turn the page to page 63. And there you'll find the discovery affidavit. So with discovery, I suppose one must first and foremost understand what the purpose of discovery is. And if you understand the purpose and the use of discovery as a mechanism within civil procedure, then you can understand why the principles are what they are and why it's applied in the way that they are. So essentially discovery is an important mechanism to ventilate the issues by having insight into all relevant documents. Please be mindful of the fact that normal discovery procedures don't apply for expert reports, they don't apply for plans, diagrams, photographs, etc. Those are dealt with in other rules, which we'll deal with in a moment. So this is just, I'm referring to documents. So what the principle behind discovery is for parties to bring to court all relevant documents, especially those that are not in favor of that party's case, so that there's a proper ventilation of the issues and all the parties, the court can have an objective view of all the documents relevant to the matter. Discovery is probably the most important part of civil procedure in my view. It's probably also the one that becomes the most run-of-the-mill with practitioners and most often abused by parties. Okay. Who must discover? Parties to a suit must make discovery. So if you're a plaintiff or a defendant, whether you're one of many or the only one, doesn't matter, you must discover. You are obliged to discover. If you have no documents to discover, then you say so under oath. If you say, I have, for instance, I cannot think of an instance where you wouldn't have a document to discover, but let's say, for instance, it's a claim for something having been misappropriated, funds misappropriated, and you don't have any documents, then you say you don't have documents. I have yet to see a case where I haven't made discovery on behalf of a client, or where my opponent hasn't made discovery. Even if it's just a bank statement or a deposit slip or a driver's license of some sort, there's always something relevant that you need to discover. What must be discovered? The issue is about relevance. So what is reasonably relevant to the suit? And when I mean relevant, I don't mean relevant and advantageous. I mean relevant irrespective of whether it hurts your case or promotes your case. And it's unethical for a party not to disclose documents in his or her well, it'll probably be, if they sign the founding affidavit, it'll probably be a perjury, but it's also unethical not to discover documents that are relevant to the suit, and especially documents that advance your opponent's case. From a practitioner's point of view, once a practitioner is aware that documents are in existence and their client doesn't want to discover it, that practitioner is in a dilemma and probably have to withdraw due to ethical reasons. Okay. So, I mean, the client's position is protected by attorney-client privilege, but the practitioner won't be able to continue to act for that party. When must discovery take place? Under the new rules, and it takes place usually already here, in the sense that it's part of the case plan. Witness statements and discovery are catered for in the case plan, which we'll do later, but it won't happen before, although it's regulated here, it won't happen before close of pleadings, because you wouldn't know what's relevant unless pleadings have closed and you see what is in dispute. It must be relevant to the issues in dispute. So if, for instance, the parties agree in a matrimonial suit that there were 3 minor children born of the marriage and they are so-and-so and they were born on this date, discovering their birth certificates would probably be superfluous, simply because it's not relevant to the issues in dispute. Everyone is in agreement that those are the children born between the parties from the marriage on those dates, and these are their names. So why would you need to discover their birth certificates still? But if that had been in dispute, if the plea had said, no, well, I'm not the father of this child, or he wasn't born then, or he was born, then it becomes, then it becomes a relevant document to the issues in dispute. All right, so you can only conceivably know what is relevant once pleadings have closed. But so although at this stage already discovery and witness statements are dealt with, it really is strictly speaking a pretrial procedure. So it's only done once pleadings have been closed. What I've seen in case plans in some of the managing judges' courts is that the parties say, we will deal with discovery and or witness statements in the case management report. So we'll deal with it there. So as long as it's a pretrial procedure that's regulated and the parties agree, let's not at case planning deal with it. Let's call a status hearing or a case management, and then we'll deal with these issues. It may be that what's relevant changes when an amendment comes. And certain things certain issues become relevant that weren't relevant or weren't an issue before, and then it may be that parties are required to do additional discovery to cater for an amendment. Okay. So when discovery takes place, after close of pleadings, before trial. And generally, in the way that I try to conduct trial preparation, is for discovery to take place, and after discovery, for sufficient time to file witness statements. Because you would have to, in your witness statement, deal with documents relevant to the suit. You can only deal with those once full discovery has been made. So to have discovery and a week later witness statements is, I suppose, in a complex matter particularly, is probably short-sighted, for the simple reason that that would mean that you have counsel sitting by waiting for the box of discovered documents and then immediately consulting client in that week and then rushing to draw, and that's where issues come in, and witness statements needs to be changed because it was done under time pressure. So when it's a complex matter or discovery is anticipated to be, and I mean, I've had discovery where they bring 7 boxes full of lever arch files to my office. That's discovery. It takes you a month just to get through everything. So then you want to, I suppose, if you want to have a pragmatic approach to pretrial procedures, and especially considering the fact that once pretrial procedures are finalized, it takes some time for you to get on the court roll. At present, we're looking at dates for matters that are ready to be set down now. We're looking at dates around about August, September next year. So I suppose but I mean, that's something that'll sort itself out hopefully going forward. So be mindful of what you're dealing with. The discovery in A run-of-the-mill type of opposed divorce action is going to be the marriage certificate. It's going to be the antenuptial contract, if there is one. It's probably going to possibly birth certificates of children, and then if there's a maintenance issue, some documents. So we're not talking about boxes full of documents, generally in the run-of-the-mill. But if you're talking about $40 million action for damages suffered as a result of a building contract that issues arose, you can imagine the FIDIC contract in its own is this big, and then you've got all the documents and all the certificates, completion certificates, and you've got, I mean, at the end of the day, you're going to be sitting with quite a significant amount of discovery. And then you want parties to have access to all the documents, and you want the discovery process to be finalized before they proceed to draw witness statements and then refer to the documents in their witness statement. All right, so what to do when discovery is not made or is not sufficient? That would be in an instance where you receive your opponent's discovery affidavit. For instance, let's again go back to a matrimonial suit. So I claim maintenance for the minor children, and that maintenance claim is opposed, and the defendant says, I can't afford to pay maintenance in the amount of $50,000 a month for the children, and that's something that becomes an issue for determination in the divorce. Then discovery comes, and there's no financial documents of the defendant attached. Then I, as the plaintiff, would want to see bank statements. I would want to see salary advices. I would want to see means documents evidencing the defendant's income. So I would seek specific discovery, and that's usually also dealt with in the case management. So once discovery has been made, you would be able to establish whether discovery was sufficient or not, and if you need to make specific discovery, the date for filing such a notice and the date for replying thereto would usually be dealt with in the case management process. But you wouldn't know whether you need to apply for specific discovery or for discovery at all. So it's really compelling. So you'll file a notice saying, in addition, and I just want to take you to Rule 28, I think it's sub 8. Let's just see. Yes, it's sub Rule 8. So it says, if a party believes that there are, in addition to documents, analogues, or digital recordings disclosed under sub Rule 4, other documents, including copies thereof, or analogues or digital recordings, which may be relevant to any matter in question, in the possession of any other party, and which are not repetitive or a duplication of those documents, analogues, or digital recordings already discovered, then you file a notice in terms of the sub Rule 8, calling upon that party, and then you must list. It's not a fishing expedition. You need to list the documents that are required. Now, at this point, I should perhaps just say that, or maybe I should ask you, are you entitled as a defendant, say for instance you are the defendant in the matter, there's a particulars of claim, and in the particulars of claim, reference is made to an expert report by Dr. X. Reference is made to a blood pressure chart. It's now a medical negligence claim. Or let's say it's a POC for divorce. Reference is made to an antenuptial agreement, and reference is made to a letter by the defendant. Okay. So in these instances, are you as defendant entitled to discovery of those documents before you plead? So in exceptional circumstances, a defendant would be able to seek, well, I mean, in terms of the previous rules, there was a specific rule dealing with discovery pre-close of pleadings. And what the rule said was that, yes, you, Mr. Defendant, you are entitled to discovery of these documents, or even documents, specific documents, to which reference, not necessarily to the document itself, but from which references are made in the particulars of claim, or from which inferences are drawn. So you would be entitled to file a notice in terms whereof you can seek discovery of specific documents, a very specific, limited amount of documents that it's not a fishing expedition, you're entitled to seek. Now my question is, and I'm not going to give you the answer now, I'm going to ask you to give me the answer later, whether that's still doable under the new rules, whether you can still do that. What I've just explained to you now, whether in terms of the new rules, whether a party is still entitled to that. Okay, so I'm not going to give you the answer, you're going to give me the answer. Who decides admissibility of documents? Exactly, so it's not for you to decide whether. You may think it's inadmissible, your opponent may want to rely on it, you may think it's inadmissible, you may discover it, and your discovery doesn't mean it's been admitted in evidence. It's just giving all the documents to all the parties. And if a document that has been discovered is inadmissible, the other party doesn't lose that right to raise that objection at the trial. You simply get up and say, my lord, I object, this document is inadmissible. And then that is dealt with there and then by the judge. But it's not for the party to decide what is admissible and not admissible and then leave documents out. Of course, there are exceptions to what can be discovered. Documents subject to legal privilege need not be discovered, and you'll see, and we'll deal with the actual example of the discovery affidavit in a moment. The more difficult question, I suppose, is when it comes to confidentiality. Confidentiality per se is not a bar for discovery. So just because something is confidential doesn't mean you're entitled to withhold discovery thereof. So what should be done is, for instance, in a matter that I've dealt with recently where it's unlawful competition matter, the specific discovery was of the request for specific discovery by the defendant of my client was of such a nature that it would include documents containing trade secrets, information that the discovery thereof, the benefit of discovering same, is outweighed by the prejudice of disclosing the confidentiality of these documents. So what one needs to do is to be forthcoming, to say, yes, these documents are in existence. I'm litigating against my competition. If I give them these documents, they will undoubtedly use it to further undermine my position in the market and further unlawfully compete with me. Therefore, I object to making these available. And you list those documents. And the court then makes a decision. So there has been instances where the court has received documents. I've acted in a matter where there was a report. It was a young girl who was sexually assaulted by, she was 4 years old, and it was 4 boys of about 7, and there was a civil suit. And so it appeared that the school had compiled a report after speaking with one of the boys' fathers. And the plaintiff wanted insight into this report. At the school said it was privileged, and there was a dispute as to whether this document was in fact privileged. So what had happened there was that it was given to the judge and not to the plaintiff, and the judge then made a ruling saying it is subject to privilege. So the other side never saw the document, never led evidence on it, it was ruled to have. So these things happen. Ultimately, the decision is the court's decision, whether a document is privileged, whether it's confidential. Even confidential documents have been given to judges and not to the other side, and the judge then makes a ruling on whether this should be discovered, or what's the purpose of discovering the document, and is that outweighed by the prejudice a party will suffer in making these confidential documents public? So I think the key here is to list what you have, give what you think you must give, and list those documents that you think are privileged, and list those documents that you object to discovering based on confidentiality or some other impediment, and then the court will decide if the other party wishes to pursue that. So if it's not made or not sufficient, your question was, just remind me again what your question was. Just want to make the admissibility. So we've dealt with that. So the court will decide on the admissibility. That's why, strictly speaking, discovered documents should not be placed on the court file before the trial. It is done for some reason in many trials, because the court should not be receiving a document unless the parties agree that it's admissible and the court agrees to accept it. So the court should actually disregard discovered documents that have not been handed up during evidence. It's not like you say, here judge, take all these files and now you go make a decision. You need to lead evidence, and if you don't present a document during evidence as an exhibit, the court is entitled to disregard that because it's not before the court for evidence. The court won't go and page through the discovery affidavit. Oh yes, plaintiff, I see here is an agreement that supports what you said, but really, and you didn't hand. But I'm going to be nice. I'm going to take it in, and I'm going to refer to that in my judgment. It hasn't been handed up as an exhibit. It's not before the court. So discovery is for the benefit of the parties, and principally to remove the element of surprise and to open up all the cards so that the issues can be properly ventilated, to give all parties a fair chance before court. Does that make sense? They should deliver what is called a discovery affidavit, wherein all these documents are listed. That goes to court, to all parties. And then, strictly speaking, the discovery bundles is exchanged between the parties. And then what also is very of much assistance, it's difficult where you have litigants before you who are in acrimonious and their counsel don't seem to get along. But where parties are able to come together and in a pragmatic approach to trial, you would have what is called a trial bundle. The parties go through all the discovery and they say, of these 7 boxes, this is what we'll be using. And they'll prepare a trial bundle, paginated and indexed, and say, of all the discovery documents, Judge, we've gone through them, we want to use these documents, and this is all we're going to refer to. It doesn't remove your right to refer to another discovered document, but if you've done proper preparation and issues don't crop up during trial, then generally speaking, you should be able to compile a trial bundle beforehand for the benefit of the court and the witnesses. Everyone's on the same page. You page to page 70 of the trial bundle, you know, this is document so-and-so. They marked in the bundle, all the witnesses have the same documents, and we're all on the same page. Otherwise, you're paging through the file here, discovery by the defendant, okay, but item so-and-so, okay, let's go to the plaintiff's discovery, and then it's documents all over. What's difficult from a practical point of view, in my experience, is a trial on e-justice, because all the documents are uploaded. So it's difficult to compile a trial bundle. I don't do that, but my instructing practitioners at times have their hands in their hair saying, well, I don't know how to compile this trial bundle. So I tend to, in any event, prepare a separate bundle, which I hand to the witness, and because I'm handing it to the witness, I give it to the opponent and to the judge, and if the judge wants to throw it away afterwards, then he or she's welcome to do that, but at least during the proceedings, it assists in things going faster, because having to open, you know, e-justice loads, I don't know whether you've had experience with e-justice, it loads these documents in PDF, and often the practitioners don't really know how to how to number it, and then it cuts the document off, and then it's part 1 and part 5 is down there, and it really is it's too much of an all over the show, but that's, I think, issues that will sort itself out going forward, because these must be things that are experienced by judges and practitioners alike in trials. But discovery bundles are exchanged between the parties, and then it doesn't mean that because we've given each other, or even because it's placed on the court file, that it's now suddenly before the judge. It's not before the judge. It's only before the judge if it's handed up as an exhibit and accepted as an exhibit by the court at the trial. Or if it's part of a pleading, because remember, an annexure to a pleading is also part of the pleading. So if a contract is attached to the particulars of claim, it's before court. Okay, let's go to page 63. I just want to at least finish discovery before tea. Go to page 63 of this copied file that you have. You all have that with you? Okay, so this is what a discovery affidavit looks like. It's made under oath. And then paragraph 1 is just the introductory of general who the deponent is, etc. And then I have in my possession or power the documents relating to the matters in question in this case, set forth in the first and second parts of the first schedule hereto. I have in my possession or power. So what is the relevance of saying possession or power? What you are able to disclose. So what you have under your control. So it may be that my bank statements are not all in my pocket or in my file at home, but I have control over those documents and I can easily get them and discover them. Okay, so your obligation will stretch not only to what you have physically with you, but also what you are able to get, what you have control over. So I'm able to go and get all my invoices from my secretary. So even though they're not in my physical possession, but in hers, I'm able to get them and to discover them. And then it's listed in the first schedule. So let's turn to the first schedule, which you'll find on page 66. So you'll see that there are a number of documents listed. They are described as an item. So you must be able to actually ascertain from the item description what document it is that's being discovered. So for instance, you'll see some of them are dated. It's always good to have a date in the discovery affidavit simply because there may be 2 accident reports, so which one has now been discovered? Because if you haven't discovered a document, you're not entitled to rely on it. Okay. So then you must say whether it's an original or a copy that you will be discovering, and that's then set out in the first part. Goes up to item 12. Then it proceeds to paragraph 3 to say, I object to the production of the said documents set forth in the second schedule hereto on the grounds that they fall within the doctrine of the legal profession privilege. Okay, so that's what I said. That's one of the things that, one of the bases upon which a party can object. Now what you'll see in Schedule 2 is correspondence between attorney and client, statements of witnesses, instructions to counsel, all other documents and correspondence brought into existence to enable the plaintiff's case, and correspondence addressed without prejudice. Now, this is a general form. This is how discovery is generally made. Strictly speaking, these items should be listed. The other party is entitled to know on what date you wrote, what the dates of these documents are, what they are termed, etc., without disclosing the document. The other party is, of course, entitled to know, strictly speaking, same as with the previous item. Okay, but it's not done, and it hasn't been an issue except in one instance where I appeared, where the one I've just referred you to, relating to the report that was filed, which came to the other party's knowledge. The thing is that such a report was in existence. The thing is, the other party should be able to see what documents you are objecting to, not the actual document, but what it's titled and when it's dated. For instance, documents preceding the anticipated litigation will probably not be of an attorney-client nature for purposes of that matter. So privilege, legal privilege has certain aspects, requirements, and one of them being that it's the communication of the document is brought into existence in anticipation of litigation. So if, for instance, it's an opinion dating 3 years before the litigation ensued and there was no prospect of litigation at all, whether or not it's privileged is questionable, and therefore I think the opponent is at the very least entitled to see the dates of those documents and whether they're letters or opinions or what they are. Okay, so not all documents are privileged. Sorry, I'm talking about without prejudice offers. Without prejudice offers are only privileged when they're made in anticipation of legal proceedings. Same with privilege. If you haven't foreseen litigation, then it's questionable whether it's actually privileged communications or documents, etc. So for the purpose of that matter. So at the very least, I'm not going to teach you about privilege. That's something that you should know, but know that a party would be entitled to at least know the title and the date of a document in order to establish whether privilege in fact applies. And then what you would have here also, before we get to paragraph 5, now paragraph 4 is part of paragraph 3 where it just says, I object to producing these documents. Now you see, I object to the production for inspection of these documents, but we don't know what these documents are. It's like a blanket sort of refusal. And then what you would usually have before paragraph 5 is where you would insert, for instance, documents which you object to not from a privilege point of view, but perhaps, as I've explained earlier, from a confidential point of view. So you'll put that in there, you list those documents, and then the court will deal with whether you are obliged to disclose those or not. All right, and then paragraph 5 is very important and is often overlooked by practitioners. The importance of this is often overlooked by practitioners, in that discovery becomes sort of a run-of-the-mill type of thing. Please bring me all your documents. What the deponent is saying is that, according to the best of my knowledge and belief, I have not now and never had in my possession, custody and power, or in that of my legal practitioners or agents or any other person on my behalf, any documents or copy of or extract from any document relating to any matters in question in this cause, other than the documents set forth in the first and second schedule attached hereto. That's quite a far-reaching statement to make. So I suppose deponents, and particularly their counsel, legal counsel, should be wary of allowing deponents to make such statements under oath if that's not entirely correct. If you have previously, if a party previously had under its control or in its possession or knew of the existence of a document relevant but which it no longer knows of or has, that should be stated in the discovery affidavit. It should be stated that I know that there was a written agreement, but it has since been eaten by the dog, and therefore I don't know where it now is. You see, that's it. These are the things that should be in your discovery affidavit. So essentially, the deponent then signs, and the discovery affidavit is sent, and then there would be some arrangement between the parties, generally in the case plan, dealing with the exchange of bundles, discovery bundles between the parties, so that all parties have copies of the discovery. There are also instances where documents are under the control of a third party who is not a party to the suit. Would a party be entitled to seek discovery from that party? Can you seek discovery from a party who is not a party to the suit, to the case? them. The answer was yes, and I agree the answer is yes. Then it was suggested that you do that by means of an application to court. And I said, well, there's an easier way. It's called a subpoena. And what you do is you would subpoena, for instance, a bank manager, and you'd ask him or her to bring along the bank statements of a particular person or company. You could subpoena a superintendent at a hospital, and you can ask him or her to bring along certain hospital records relating to a patient. You can subpoena a doctor and ask him or her to bring along patient documents. They're not privileged. Same with psychiatrists, etc., etc. So when a third party is under control or in possession of documents relevant to the suit, you can issue a subpoena for that witness to come to court, or that person to come to court and to bring along on a specific date all these documents. And that's how you secure discovery by a third party. A subpoena is a document issued out of court. It calls upon a party to appear and present themselves at court. And in this case, a specific type of subpoena where you ask for documents to be brought along. And if that person does not appear, then I, as a practitioner, would seek a warrant for his or writ for arrest. Because they should have been there. So that's what a subpoena is for. You subpoena someone, and if they don't appear, that principle is tried even in the magistrate's court. So no, the person on whom a subpoena is served doesn't have an option. Of course, if it's impossible for that person to appear, then that needs to be considered by the court. And if it's a situation where these documents are no longer in existence, or they are not in the person's possession or under his or her control, then he or she should come to court and say that to the court, and the court will then listen and consider. Well, that if the documents are given prior to that date to both parties, and both parties agree that it's no longer necessary for this person to be at court, then they can release him they can ask the court to release him under the subpoena. Most certainly, it's happened. So it can happen, but that'll be both, because if a party has been subpoenaed, it's not just one party who's entitled to release him. It should be obviously with the leave of the court, and the other party should have an opportunity to make representations regarding the releasing of that witness under a subpoena. So it won't just simply be, oh, thank you for the documents, there you go. It'll be a situation where it's agreed between the parties, or the court then orders it. Either way, the court will have to order it. Absolutely. And what has happened previously is that what's happened in practice, and it's probably a good approach to proper preparation for trial and to avoid delays at trial, is for parties to sort out their subpoenas beforehand and to actually have this person appear either at a status hearing or at a case management conference or at a pre-trial conference, so that this person comes along with the documents then, so that they are given to the parties well in advance, because not all subpoenaed witnesses are actually witnesses who cooperate with the parties. They may cooperate with the court, but not necessarily with the parties. So it may be that you subpoena this bank manager. He's quite upset with the fact that he's been subpoenaed. He's not going to be nice and just bring the documents in advance. So if he's ordered to be in court, say for instance during a pre-trial conference, then he hands over the documents then. The parties make their copies, and then he can again be subpoenaed to appear at the trial if further questions need to be asked on these documents, or if he needs to be questioned relating to the documents, or his refusal to bring documents or whatever. That can always be done in advance of the trial, if it's just about the documents. It has been done previously. It can be done, but for various reasons you may only want, especially if it's a witness whose evidence is pivotal to the trial. So your purpose is not only to seek discovery, but it's also that his or her, like for instance a bank manager, all you want from him is, for instance, the account statements. So once you have the account statements, you're not going to question, he doesn't know whose account, well, he knows whose account it is, but I mean, he's not going to know what transactions these were for. He can only certify that this is the correct account and account statements. So in that instance, possibly it would serve a purpose to get the documents in advance. if, for instance, it's a witness whose evidence, who has personal knowledge and documents. So, for instance, in a recent case that I had, I appeared for one property developer and a colleague appeared for another property developer, and it related to a property that was first sold to the one party by the City of Windhoek, and then the sale was cancelled by the City of Windhoek, and then it was allocated to another party. So the one party sued the City of Windhoek for specific performance, and obviously the other party was joined because it had now in the meantime been awarded the property. So the City of Windhoek said, I'm abiding. This is what I've done. I'm abiding by the decision of the court. I'm not opposing, but the two property developers are now fighting with each other as to whether this cancellation was valid and who must now get the property. So obviously the City of Windhoek's official, they're not a party to the proceedings. They're not going to come and testify. So you would want to call him or her, subpoena them to bring their documents and testify, because their testimony will be very important. So in that instance, it makes no sense to get it in advance, because you're going to have to call him or her in any event. So it will lead to delays. But you can be pragmatic, and you can be, there are certain ways in which you can try and alleviate the need to delay if it's only for purposes of discovery of documents from a third party. We've dealt with what a discovery affidavit looks like. I've spoken to you about Rule 28, Subrule 8, where you seek specific a specific discovery from another party. Now, please bear in mind that you need to be specific in what it is that you want him or her to discover. So to say all documents that were ever in existence relating to this issue is too wide, you won't get that. There's no way that a party can answer to that. Once a notice is served on a party to deliver this specific discovery of documents, there's a specific way in which a party needs to answer to that notice. And you'll find that in Subrule 8. And we're looking specifically at Subrule 8b, Roman 2. A party must deliver, Roman 1, deliver the documents, analogues, or digital recordings to the party requesting them within a specific period of time, or state on oath or by affirmation within 10 days of the order that such documents, analogues, or digital recordings are not in his or her possession, in which case he or she must state their whereabouts if known to him or her. So it would be, I don't have this in my possession. The last time I saw it was in Mr. X's office. Or I've never seen such a document in my life. I don't know whether it's in existence. Or I had it, but it's since been destroyed in a fire. Okay. So this is what is expected of a party when answering a request for specific discovery. That more or less takes care, in broad terms, of the discovery process. I've dealt with a supplementary discovery. You'll find at page 95 of the bundle, the bundle of pleadings that you were given. You'll see there's a additional or supplementary discovery. Now, again, it's sort of a run-of-the-mill type of document that's drawn up, and I'm just giving further documents now. One would have thought that an explanation is necessary, given the fact that in the previous statement you say, I'm not aware of any other documents in existence that are relevant. So why the supplementary discovery affidavit? It could be that you've come across new documents, that you made a mistake, that you accidentally omitted something, that new issues arose between the parties, which now gave rise to the new further documents being discovered. But one would expect in a supplementary affidavit that a party at least sets out what exactly gave rise to them to the need for filing a further supplementary affidavit, discovery affidavit. The next question that arises with supplementary discovery is simply, What is it necessary to obtain leave from the court? Strictly speaking, yes, because discovery has been arranged and agreed upon, and the parties have complied with that. Now you want to revisit that and introduce further documents, you would probably need leave from the court. Some judges are more relaxed and allow parties to arrange this amongst themselves and then sanction or order such a filing of further discovery, and where the parties are not really an issue, that's fine. Other judges are very strict and tend to say, you've missed the bus, you would have to apply for leave to file a further supplementary affidavit. What the reason for that, the reason why parties can't just file supplementary discovery affidavits as they please, is to avoid a situation where the rules try and force parties through the case management process to get the proverbial ducks in a row. They cannot sit back and relax, and then shortly before trial they want to run around. And in the old dispensation, various matters were postponed due to discovery not being done, due to these pre-trial procedures, expert witnesses not being filed summaries for, or statements or whatever, notices. These pre-trial procedures often caused delay and a postponement of matters on the roll. Now you can imagine, court roll time is precious. We only have so much of it. It's not infinite. And now, more often than not, you have 4 matters on the floating roll and not one of them is proceeding. So other matters that's now further down the line could have actually proceeded and could have been finalized, which is why the rationale behind getting parties to get their ducks in a row while advance of the trial. So you shouldn't be allowed to simply at a whim file further discovery and whatever supplementary discovery because it is abused. What do people do when there's a system? They try and get around it. What do people do when there are rules? They try and make life as easy as possible within those set of rules. So what do? Attorney says, oh my word, we need to file a discovery affidavit next week. I haven't even gone to, just make a list and we'll file it. And then we'll deal with supplementary discovery. And then comes preparation for trial, and 5 days before the trial, there's a supplementary discovery affidavit with like 57 documents. You see. So that's why it's really a process which should be well managed by a judge to make sure that the parties properly prepare. Circumstances arise. You can't be too stringent. Sometimes parties make an honest mistake and omit to actually add a document which they should have. That's easily explainable, and you wouldn't expect that if you've made an honest mistake that you've just forgotten to add 3 files. You see. So I'll be with you in a second. Same principle applies to documents which come to your knowledge afterwards, or issues that have changed through amendments that require further discovery. These things happen, and you need to be mindful of that. But within having said that, please be mindful of the fact that if parties can abuse this process, they will. They will, and other litigants need to be protected against a situation where you do a flimsy first off discovery affidavit, and then comes this magnitude of a supplementary discovery. That's the one. I never have, and I never will have, and I know. That's exactly what I referred to that earlier before the break, and I said it's a very wide and sort of difficult thing to say, because you're saying under oath that you have nothing else, you never had anything else. So that's why I'm saying in a supplementary affidavit, discovery affidavit, one would expect at the very least that a litigant explains why, despite what is stated there in the original discovery affidavit, I now want new documents to be discovered. You see what I'm saying? And it's been cross-examination material for years, and practitioners just continue to disregard the importance of making an allegation as in paragraph 5, which means that you should have been diligent as a practitioner or as a litigant, and you should have gotten all the documents ready. And now that paragraph, more often than not, leads to a finger pointing. Yes, but my lawyer did this. Then the lawyer said, no, but you did this. And then that's what happens. It's just because it's poor preparation. It'll probably be one of the bases that you use in opposing further discovery. But whether you're entitled to use that to stop any further discovery ever, it's probably not going to take you very far, because the court will take into consideration the circumstances. If it was malicious and the document to be discovered is to your detriment and it's close to the trial, etc., then the court may actually just refuse the party to proceed. But then again, we get to postponements and cost orders and condonation. We'll get to that tomorrow. And so it's a difficult question, but no, I don't think that a party can simply rely on that as conclusive that the other party will never again be allowed to discover. Will definitely go to his or her credibility, won't it? In fact, you'll probably be shocked to know in practice that those documents are more often than not drawn by a secretary. More often than not, the lawyer doesn't even see that document before it's signed by the parties, or by a very junior practitioner. And that's why I said right at the beginning, it's probably the most important process or part of pre-trial procedures. But its importance is so often overlooked by practitioners. And it's left to people to do who, like I said, secretary, paralegal, someone who, and that's how, so you're quite correct. That's why the supplementary affidavit and the affidavit in this file looks exactly the same. It's copy and paste. So that's why I said people should be wary of what they let their clients sign, and clients should be wary of what it is that they're signing. And discovery should actually get more attention from practitioners than it possibly has. And often, if you do proper discovery, it often leads to a settlement. That's how I experience it. All right, so that is discovery, supplementary discovery, discover documents. Please again bear in mind that having made discovery does not mean that the documents are now before court. They still need to be handed up as exhibits unless they are attached to pleadings. You'll find reference to that in Rule 28. And that then deals with discovery. Okay. Expert testimony, plans, photographs, inspections, medical examinations. So you'll have to have a look at Rule 29, 30, 31, 33, and 36 for purposes of this. I won't spend too much time on this. Please bear in mind an expert is there to assist the court. So an expert doesn't make the decision on behalf of the court. An expert can, for instance, say, where, let's say, medical negligence, you have a doctor or a professor in medicine who comes and testifies and says, well, in my view, the doctor, who's the defendant in the matter, didn't properly attend to the patient, should have done it. The expert doesn't make the finding of negligence. That finding is made by the court. So the expert never makes the decision on the court's behalf. Now my question is, can you call a legal expert to testify in court? Yes. Can you make use of a legal expert? I'm not a legal expert apparently yet, but I'm aspiring. Can you make use of a lawyer or a senior advocate or a professor in law, any legal expert? Who says yes? In any possible, fathomable situation, are you ever entitled to call a legal expert to give evidence on legal matters in a court of law, in a high court? You wanted to say? On legal issue. Well, I mean, I am also an expert on my husband's state of mind, but I'm not going to say a legal expert will testify only on legal issues. Okay, to testify on legal issues. So it's called it's really called forensic experts in the sense that we spend more time litigating. And the idea behind a referral, I'm not here to advocate referral or non-referral bars, I just like my work and I like to do it. But the idea behind it is that when you're a legal practitioner and instructing counsel, your practice is of such a nature that you often don't have the time to prepare for proper litigation, in the sense that you have 1,000 files, whereas I may only have 100 files at a time. So I have the time to spend a week in court and focus only on that matter. So it really is a matter of logistics. Then, of course, my fees per hour is, even though I'm 14 years in practice and there's a junior lawyer who's now 5 years, her fees might be more than mine, simply because her practice is more expensive than mine is, because I need a secretary and a telephone and a computer to operate. So there's different nuances, but to answer your question, I don't specialize in a field of law. I am a qualified lawyer, so I need to be able to do all kinds of law. But it's also my ethical duty to tell a client when something is not within my abilities. So yes, I don't have much exposure to criminal law. I should be able to do it because I'm an admitted practitioner. So I should be able to get up in a criminal court and help myself. But I will say to a client, well, I urge you to consider perhaps appointing my colleague who does more criminal work than me, and she or he is better equipped to assist you. But I'm not allowed to say, oh, no, sorry, I specialize in this, and I'm not even allowed to actually not accept a brief if I am available, unless I have an ethical issue why I can't accept the brief. So you say yes, you think so, because people specialize in different areas of the law. So maybe a judge needs assistance in certain areas of the law. That's one qualification. Well, I think in most cases where my clients have an interest, I want to assist the court by telling the judge what he or she should find. But that doesn't mean that it's allowed. Okay, so essentially the answer is no. You don't call legal experts to assist judges. Judges, if they are not competent to make a finding, they shouldn't be a judge in the first place. That is the answer. There are exceptions. The exception is this. When you want to prove foreign law, you need to call a foreign legal expert to come and tell this court what the law is like in Germany, what the law is like in France. It may be that foreign law is applicable. Remember, if you don't prove foreign law, what is the presumption? It's the same as our law. Okay? So you need to, if you want to rely on foreign law that's different from our law, you need to prove that. And to prove that, you call a foreign legal expert. But you will not call a legal expert to tell a judge what the law he or she is applying is. Never. Well, I mean, you can try it and then see what the judge says. Let me know what the judge says. But no. So an expert is someone who assists the court. It's someone who knows a field other than law, which the judge is not an expert in, because the judge is an expert in law. And then that expert must be duly qualified. And by qualified, I mean actual qualifications and or experience. So in certain fields, such as, let's say, cattle farming, you won't necessarily have a qualification. You may have an agricultural qualification, but cattle farming and the nuances of cattle farming or meat production, export of meat, those things are things that you really, you become an expert on when you spend time in the industry. So a cattle farmer who's has been farming cattle for meat production for the past 20 years on a large scale would be someone who could tell you something about the procedures for exporting of meat, who can tell you about the, objectively speaking, can tell you about meat prices, can tell you about meat quality, can tell you about when cattle are weighed before they are slaughtered, and what's the dry weight and the wet weight and the whole. The only reason I know these things is because our job is interesting. You get to deal with all these people all the time, and you get to know about various areas outside the law. But what I'm trying to say is it depends on the field. So you won't get someone who has been walking around in hospitals for the past 10 years telling you about medical negligence. He or she needs a qualification. And if you want to talk about medical negligence of a surgeon, you don't get a gynecologist to come and testify, you get a specialist surgeon, preferably someone who's lecturing at a university of some sort and is able to come and assist the court. in making a finding, doesn't make the finding on the court's behalf. So you'll have to file a notice, and you'd have to say, this is the expert I'm calling, this is what his name is, this is what he or she is, these are his or her qualifications and experience, and this is what they are going to come and testify on. And then you get the expert summary, which is the expert witness statement, which says usually what parties do. I think it depends on the judge that you're appearing before. You file your summary, which is a witness statement for an expert, and you attach the report either way. You can either duplicate the whole report in the statement, or you can, for purposes of brevity, say, highlight those portions that you want to rely on, say the report is attached, I refer to it by reference, I will be referring to it, and from the report the following are this is what I've done and these are my conclusions. The expert will have to say what he's done, what his mandate was, how he's done what he's done, and what the conclusions are and why he arrives at those conclusions. Okay. Otherwise, it's of no assistance to the court. So the whole idea of experts is to be of assistance to the court. The question you need to ask yourself, is this something that requires expert evidence or not? In other words, if my client says his car was damaged to the tune of 50,000 Namibian dollars, how do I know? Just because my client tells me, or because my client went to an assessor who looked at the car and said, you know what, this car is damaged and you need to replace this, and as a result, this is what these cost, so this is what the damage to the car is. Or a panel beater who does this all the time and knows what parts are worth and what it costs to fix a car. You'll get some of these panel beaters, they've been operating for 30 plus years. You can wake them up in the middle of the night and they'll be able to tell you what the damage to a car is worth, and etc., etc. So there you'll need an expert. If your client says, I sold 30 head of cattle to the defendant and we agreed that we will use the prevailing meat price on that day or that month. Is that something for which expert evidence is required? Probably not. It's an objective, determinable fact. So the situation will dictate whether experts are necessary. They're very important in a trial. Please remember, they never make the decision. They can reach a conclusion and say, based on my experience, this is what I think, but it remains opinion evidence. Opinion evidence can only be used when it's relevant and of assistance to the court. Okay. Plans, photographs, inspections, Rule 36. I'm not going to be spending a lot of time on that. Just know that if you want to make use of plans, photographs, or you want to do inspections, you use with a mechanism in Rule 36. You can read it. It's straightforward. Same with medical examinations. That's Rule 33. Please have a look at that. That is where one party would want to subject the other party to a medical examination. For instance, where your claim is for damages for loss of a limb and loss of amenities of life, you would want that party to undergo a medical examination by your own expert in order to prepare your own report. I've often heard in court practitioners saying, well, we didn't file an expert report yet because we didn't know whether the other side will be filing an expert report. Now, that may hold true for a defendant who doesn't bear the onus. But the thing is, a party who bears the onus cannot wait to see what the other side does. He or she must make whatever arrangements need to be made in order to prove their case, which would include lining up the necessary experts. Okay, then we move on to request for trial particulars. That's Rule 26. Strictly speaking, with the new rules, the whole idea of further particulars fell away. So you can't, during pleading stage, as I told you yesterday, you can't seek trial particulars. But what has happened is that in terms of the pretrial procedures, and in particular, if we just go to Rule 26, you will see Rule 26 deals with the pretrial conference. So at the pretrial conference, the court accepts that discovery has taken place, witness statements have been filed, and all of that has been done. And as a result, this matter is now ripe for trial, and therefore the parties are given having considered all of that, the pleadings, the discovery, the witness statements, there may be some questions that arise from that may be answered in advance of the trial and may alleviate the need to, or may clarify certain issues, or alleviate the need to actually decide that issue, and therefore the court will allow the parties one last chance. And the only reference in the rules is sub-rule 6L, which says particulars required and necessary. Those are the important considerations, and that is what will guide whether the court will force a party to provide such particulars. Required and necessary for trial. And the party giving trial particulars must identify by name, job title, address, and telephone number of all factual witnesses who assisted in the preparation of the particulars, and further identify and describe all documents that the receiving party has relied on to assist him or her in preparing the particulars. So it's not really the old trial particulars. What do you say about that? What do you say about that? What do you say about, do you admit this? Do you admit that? That's not what this is about. It's where, for instance, in preparation for trial, look, I mean, it's used in practice, I've seen, by practitioners to become a sort of the old request for further particulars, but that's not the purpose. The purpose is to clarify issues that have arisen in the pre-trial procedures and in order to prepare for trial. So it may be that you say that you made these payments on that day. To what account number